In today's video, I'm going to talk about applications to the European Court of Human Rights. An application to the European Court of Human Rights offers an opportunity to have checked by an international court whether an action by a state violates you in one of your rights under the European Convention on Human Rights. The European Convention on Human Rights, short ECHR, is an international treaty. States which sign it undertake to guarantee certain rights and fundamental freedoms to everyone within their jurisdiction. The rights enshrined in the ECHR are generally recognized basic democratic rights, such as the right to life, freedom from torture, freedom of expression, or the right to a fair trial. Persons who believe that a state has violated one of their rights under the Convention have the possibility to submit an application to the European Court of Human Rights. The European Court of Human Rights is an international court based in France, Strasbourg. There are 47 judges at the European Court of Human Rights. One judge is elected for each member state of the Council of Europe. If someone deems that his rights under the ECHR have been violated and submits an application to the European Court of Human Rights, the court examines the case and establishes whether there has been a violation of the Convention. In principle, the court is confined to stating that there has been a violation. It has no authority to quash a judgment or to order a retrial at the domestic level. However, the laws of most member states contain provisions to the effect that persons who participated in legal proceedings which involved a violation of the European Convention on Human Rights have the right to a retrial. That means that a judgment by the European Court of Human Rights is the basis to get a new trial at the domestic level. Thus, an application to the European Court of Human Rights basically offers an additional legal remedy when all legal possibilities are exhausted at the national level. In addition to finding a violation of the ECHR, the European Court of Human Rights can also order states to pay compensation. However, it is important to note that an application to the European Court of Human Rights is subject to certain formal requirements. The two most important ones are the exhaustion of all legal remedies at domestic level and the deadline. An application to the European Court of Human Rights is only possible when all legal remedies at the national level have been exhausted. This means that the applicant has to go through the entire process of appeal, and only if he has no more avenues to defend himself against the violation of his human rights, he can turn to the European Court of Human Rights. Applicants have to exhaust all legal remedies which are effective. This means that all legal remedies which can in principle help to put an end to the human rights violation have to be used. Sometimes it is difficult to assess which legal remedies are effective. As a rule of thumb, applicants are required to take one set of proceedings to the last instance, but they're not required to initiate several sets of proceedings. Sometimes it is difficult to assess which legal remedies are effective and have to be used. As a rule of thumb, applicants are required to take one set of proceedings to the last instance at the domestic level, but they're not required to initiate several sets of proceedings. For example, there was a case in which the applicant complained about malpractice in a hospital. In principle, it was possible to file a criminal complaint or to sue the hospital for compensation. The European Court of Human Rights ruled that the applicant had to do one of those things, but not both. After the criminal complaint did not yield any results, the applicants did not have to initiate civil proceedings in order to exhaust domestic legal remedies. She could proceed to the European Court of Human Rights. The second important formal requirement is the deadline. An application to the European Court of Human Rights has to be submitted within a certain time frame. At the time of this recording, that is in November 2021, the deadline is still 6 months. However, in August 2021, the deadline has been shortened to 4 months. The change will become effective in February 22. From that time on, the deadline will be 4 months. The deadline is calculated from the moment in which the decision regarding the last effective remedy on a domestic level is received. To submit an application, applicants have to use an application form, which the European Court of Human Rights has published on its website. The use of this form is mandatory. If applicants do not use the application form, the applications can and will be rejected. When the European Court of Human Rights receives an application, it first registers it. Then it roughly examines whether all formal requirements for lodging an application have been met and whether the substance of the application requires further examination. When the European Court of Human Rights receives an application, it first registers it. Then it roughly examines whether all formal requirements for lodging an application have been met and whether the substance of the application requires further examination. If the court comes to the conclusion that this is not the case, it can reject it by a decision which is rendered by a single judge. In that case, the applicant gets a short letter with a very short reasoning, which basically says, "We do not think that there's a violation of the ECHR." If the European Court of Human Rights is of the opinion that the application deserves a more detailed examination, it informs the government of the state against which the application is directed. Then the state has the opportunity to respond, and the applicants can reply to the response. In the vast majority of cases, the procedure before the European Court of Human Rights is in writing only. In very few cases, there is an oral hearing. At the end of the proceedings, the court will give a judgment and rule whether a violation of the European Convention on Human Rights has taken place. If so, it will also decide on compensation. Depending on the outcome, the judgment may be a basis to ask for a renewed trial at the domestic level.